So to understand where we get our constitutional tradition, there are a variety of things we have to look at. We have to look at the lessons of the past the founders learned. We have to look at their understanding of English common law. But there's some immediate things in their world that are also really important to understand. One is their experience during the American Revolution, fighting this war. Second is how to deal with government. They have this fairly weak government, the Articles of Confederation, because they're so worried about a strong government that they're fighting against, the British Empire, the strongest, most powerful nation in the world. And then there's the geopolitical realities where they've got hostile Indian tribes on their borders. They've got a Spanish presence in the Americas. And of course, they've still got English presence out in the old, what they've called the Old Northwest, what we would now call Ohio. So they've got all these things on their mind, and they've had this immediate experience with the Articles of Confederation, and there are concerns. There's been great inflation. There's the fact that you don't have a national court system in order to adjudicate claims. You've got a lot of Europeans who've lent us money, particularly British merchants, and they want to be paid, and they want to know that when they take their case to court that they're going to get a fair trial. So you've got all of these problems that the founders are aware of. And then, of course, you have Shays' Rebellion, this agrarian insurrection in Western Massachusetts that really rattles the founders, particularly George Washington. At one point, Washington says that he's afraid, and I'm paraphrasing, that we've had too good an opinion of human nature in crafting our government. Maybe we need to have a more sober reassessment. And I think one can understand one of the differences that we see if you look at the traditions of constitutionalism in the first state constitutions and the Articles of Confederation versus the federal constitution. The former, for instance, in the Articles and the Bills of Rights of these state constitutions, they almost all have a provision that talks about the need for virtue, frugality, and moderation. And they put that in a Bill of Rights as if it's not just a kind of general statement of values, that if it's something that's a fundamental principle. And we don't usually think of Bills of Rights of telling us things we have to do to preserve our liberty. We usually think of them as saying things government can't do to infringe our liberty. But here they put this injunction in there that in order to preserve liberty, citizens have these obligations. And I think one overarching theme is they realize, well, if you actually structure government where you basically ask people, would you mind paying taxes? Most people are not going to pay their taxes. And so that sense that we actually have to have a government with some compulsive authority, that's a kind of wake-up moment for the founders, and that's why we get the kind of constitutional tradition we live under today. I think if we look at the powers that are granted in Article 1, take Article 1, Section 8, where you have the power to tax, I think most students find it kind of astonishing when you explain to them the Articles of Confederation could not tax. And you try to imagine what would America be like if suddenly income taxes were optional. I don't think we'd be able to fund the biggest army in the world, and we certainly wouldn't be able to do a lot of things that we now consider to be essential for government to do. So clearly the power to tax is very, very important. And they give this new government the power to tax. And of course, it prompts some concern. The anti-federalists, the opponents of the Constitution, are worried about the power of the tax man. They are worried that taxes can be used in a coercive manner. And it's also interesting that Article 1 power talks about when you put imposts or duties, they have to be uniform. That they're really concerned that New England and the South are different, and they don't want people penalizing one region of the nation. And so they want these things to be uniform. And they're also worried, a problem they had under the Articles of Confederation, New York is the major port for not just New York, but for the surrounding region. If you allow the Port of New York and New York State to set all of its imposts, something that you don't want is, well, goods going to New York pay one freight and goods going to Connecticut pay another one. So all of these things have to be uniform and nationalized, and that's a big change for Americans who are used to dealing with this fairly weak central government. Well, clearly one of the most important changes in the text of the Constitution, if you compare it to the Articles of Confederation, is the fact that this new Constitution has the necessary and proper clause in Article 1, Section 8, which gives the new government created by the United States all powers necessary and proper to enact legislation within those enumerated powers that are given to the government. So if they have a power to tax, they have the power to enact whatever legislation is needed. So if you were a real super strict constructionist, without that clause, you might be able to tax, but you couldn't actually create a revenue department or an IRS or have tax collectors even. So you have to have the power to do what's necessary and proper to execute those powers which the Constitution gives. The big problem, and the reason why anti-federalists are deeply worried about that clause, and the reason why the Jeffersonians and the Federalists split over that clause over the great debate over the Bank of the United States after the Constitution is ratified, is does necessary mean absolutely necessary, or does necessary merely mean expedient? And I think in a way, some have argued that we continue to argue over that one clause to this day, where there are some people who believe that the government has vast, not unlimited, but vast powers to accomplish legitimate objectives. If it's not a legitimate objective, they have no power to do it. But if it is a legitimate objective, they have enormous power. There are other people who think, no, the government, it's not just a government of limited powers, but the means by which they can accomplish these powers are also extremely limited. And that's a kind of family feud that Americans have been having since the Constitution. So Article 2 sets out the powers of the executive, and that's another big change. Because remember, the American Revolution is fought against the powerful executive figure, King George III. The Articles of Confederation doesn't really have an executive except a committee. And of course, all of us who've tried to do things by committee know that that's not a very efficient way to do things. It's a good way to include many voices, but it's not a good way to fight a war, for instance. So Article 2 outlines what is a fairly strong executive, and that executive has the power to be commander-in-chief of the military, and that's quite deliberate because the feeling coming out of the Revolution and the Articles of Confederation is we need a sounder foundation for our military, and one way we can do that is by moving away from this sort of government by committee and having a single executive authority. So for instance, one of the interesting things about the executive is how they don't detail every aspect of this new powerful executive. And of course, anti-federalists are very worried about that. Of course, a lot of people feel like it's just a foregone conclusion that George Washington is going to be the first president. So even if we don't get it right now, we have time. It's really interesting that one of the first battles over how to interpret the Constitution under Congress deals with, can Washington appoint executive officers? And so the question is, if he appoints them, does he also have a right to fire them? Or do we have to endow him with the power to both hire and fire? Is it part of the essential nature of an executive to have the power to fire once you create an office? Even if, for instance, you create an office that requires the Senate to approve, like cabinet officials or Supreme Court judges. In the case of cabinet officials, can Washington fire his own cabinet? It's not clear from the text of the Constitution. That becomes one of the first things that Congress has to iron out. Another thing that prompts a little bit of controversy when the Constitution is first proposed is creation of federal judiciary. Now, on the one hand, having federal courts to settle disputes between states, disputes between citizens of the states and foreign governments, or anything involving interstate commerce, for instance. So all of those things are facilitated by having a federal court system. The anti-federalists are a little worried that these federal courts will become a means by which the federal government will increase its power, and that they won't be particularly sympathetic to American citizens. And in a way, the judiciary is the least well fleshed out of the various parts of the Constitution, and they get to that last in terms of reading through the Constitution. It comes at the very end of the document, and the idea about whether the Supreme Court will end up being as powerful, less powerful, more powerful than the other branches is very much an open question. And in large measure, one of the reasons the Supreme Court does become as powerful as it does has a lot to do with John Marshall's tenure as Chief Justice. The court before John Marshall is a much less powerful, formidable entity, and it is Marshall's understanding of the court and Marshall's ability to shape the court that in some sense puts the court on the road to becoming a co-equal branch of government. The only crime defined in the body of the Constitution is the Treason Clause, and it's really interesting that they include the Treason Clause. On the one hand, it reflects the fact that they are going to make a conscious break with common law, with the tradition under English law, where treason is very different because the monarch is sovereign, and in America the people are sovereign. It also raises a fascinating counterexample to people who think that the Second Amendment is somehow intended to give people a right to take up arms against the government, because if that were true, if that reading is true, which you sometimes hear today, then it repeals the Treason Clause, because the only crime in the Constitution that is expressly defined is treason, which involves actually taking up arms against the government. It's also interesting that in the Treason Clause, they very clearly require you to have two witnesses. They're really concerned that that you can't just bring someone in and charge them with treason on a single person's testimony. And they're also concerned that they have to be identifying the same overt act. So you can't cobble together a treason clause with, well, he saw you do this and somebody else saw you do something else, and that's treason. Those are all pretty strong safeguards against the Treason Clause being used as a tool of federal tyranny, which again is a real tribute to the way the founders shaped this Constitution as one that would be powerful enough to allow you to do what you had to do, but cognizant of the dangers of too much power being too tempting. And one of the most interesting examples of that is Thomas Jefferson, who we associate as this great apostle of liberty. He is the person who tries to use the Treason Clause in precisely the way the founders didn't intend it. He wants to really use the Treason Clause both in the Burr case and during cases of people flouting his embargo, to use treason to prosecute people who are committing crimes against the federal government. And there's a difference between prosecuting someone for committing a federal crime and prosecuting them for treason, because treason really is the ultimate crime under the Constitution. So the fact that we make it hard to prosecute people for treason is a really impressive thing about the founders' commitment to liberty. So one of the clauses of the Constitution that we don't tend to think very much about, but is very interesting from a historical point of view, is the clause in the Constitution that says that new states can be created when they reach a certain population and can petition for admission on equal basis as the other states. Because if you think about it, the 18th century and particularly the 19th century is a period of expansion of colonialism. And of course, America is a colony that breaks away from a tyrannical mother country. And so while it doesn't mean much to us today, the idea that you can create a state, of course, because we don't have a lot of land that's empty that we could create states from at this point. In the 18th century, there was an awful lot of land potentially that could come under American authority. And the idea that that land would not be held in some kind of second-class status as a colony of the United States, but would eventually have to be included on an equal basis. That is a radical affirmation of this Republican ideal. And indeed, another really interesting clause in the Constitution we don't hear so much about today is that one of the things the federal government is required to do is to guarantee to each state a Republican form of government. And again, we tend not to think about that, but again, in the context of the 18th century, that's an affirmation of this Republican understanding of politics that is so essential to understanding the Constitution. The Article 6 Supremacy Clause, which makes federal law the supreme law of the land, is a really important and ultimately turns out to be one of the most controversial provisions of the Constitution, because it clearly affirms that, unlike the Articles of Confederation, this new federal Constitution is the final word in areas where it has authority to speak. And of course, the great struggle of the early republic up until the Civil War is in those areas where the states believe they have concurrent jurisdiction, are they co-equal in interpreting the Constitution? And ultimately, what will happen in those rare cases where the Supreme Court tells a state they have to do something and the state does not want to do it? Because as Hamilton famously says in Federalist 78, the court only has the power of persuasion. It has neither the power of the sword nor the purse. So if the court wants to do something, they have to have the executive back them up. And there are a couple of quite famous examples. The most interesting one in the early republic is what happens when the Cherokee Nation in Georgia get a favorable ruling in Worcester v. Georgia. The question is, will the court be able to force the state of Georgia to follow its dictates? And essentially, Andrew Jackson has to persuade the governor of Georgia to free these two people, these two missionaries who've been imprisoned, and moot the case, make it no longer legally have any legal existence, in order to avoid having a showdown between the federal government and the state of Georgia over the court's direction that these two missionaries have to be released because they were entitled to be on Cherokee land if the Cherokee gave them permission. Well, of course, what's interesting is the polls consistently show that Americans are pretty evenly divided between two basic approaches to constitutional interpretation. One is so-called originalism, which can either be the original meaning or the original intent of those who wrote it or framed it or ratified it, depending on which version of originalism you adhere to. And the other half will think it should be a living document and we should breathe new meaning into its words. And Americans are pretty evenly divided, actually, between those two interpretations. What I think is a little misleading is even those people who believe in a living document, very few of them believe you should disregard the text of the Constitution. Most of them believe that when you interpret words like liberty, you have to breathe life into them and understand liberty as we understand it, not as they understood it, and that they gave us general language on purpose. They could have given us very specific language, and that they understood that they were pledging us to adhere to a concept of liberty, but not their concept of liberty. There clearly are some people who believe that you can interpret things like freedom of the press in a more capacious way than the founders would have. I don't think people who believe that we have a broader understanding of freedom of the press now think they're being unfaithful to the original text. I just think that they believe that the founders gave us a principle, they didn't give us a blueprint to implement the principle. And there was some recognition that the blueprint to implement the principle would change at different moments in history. Because, for instance, it doesn't say anything about the internet, but most people assume that you have some kinds of free speech rights in cyberspace. It doesn't say anything about phones. It doesn't say anything about emails, but again, or television or radio, but the general sense is that those medium are covered under the press, and the press is not restricted to hand-cranked print. And of course, one of the great con law games to play with students is to say, pose the question, is the Air Force unconstitutional? Because although the Constitution provides for the Army and the Navy, it doesn't actually provide for an Air Force for obvious reasons. So does that mean actually we have to disband the Air Force because the Constitution doesn't allow us to have one? So again, one can take the Constitution literally, as some do, but I think most people tend not to take every word of the Constitution literally. Most people fall somewhere between a radical originalism and a radical living Constitution. Most people are definitely in the middle on that one.